Whenever you're ready, Ms. Melendez.
Why, thank you, Mr. Chairman. Ladies and gentlemen of the committee, it is my pleasure to present to you AB 1869. Prior to the passage of Prop 47, the theft of any firearm was considered a felony. Prop 47 amended this statute to where the theft of a firearm, as long as it does not exceed a value of $950, would now be considered a misdemeanor, punishable by the issuance of a fine and a ticket. Simply put, this bill would restore the penalties for gun trafficking and theft of a firearm to what they were prior to the passage of Prop 47. This is a joint authored bill. My co-author is Assemblyman Adam Gray, and he's not able to be with us this morning. It's also sponsored by the California State Sheriff's Association, the California Peace Officer Association, and the California District Attorneys Association. It has received support from numerous law enforcement groups, crime victims associations, and of course local governments. And here to speak in support of the bill is Sean Rundle from the California Peace Officers Association. Thank you, Mr. Chairman. I respectfully ask for your aye vote.
Mr. Santiago.
I'd like to move the bill, Mr. Chair.
Second.
Witnesses in support?
Yep. With those recommendations, as the Vice Chair mentioned, Sean Rundle with the California Peace Officers Association, proud to co-sponsor the bill and ask for your support.
Mr. Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association, co-sponsors of the bill. Also ask for your aye vote. Thank you.
Thank you.
John Lovell on behalf of the 8 law enforcement organizations that were previously entered into the record. We're in strong support.
Thank you. Wow, we got Prop 47, firearm theft, and the NRA all in one sentence. Okay.
Members of the committee, Ed Worth of the National Rifle Association, in support of the bill.
Good morning. Kathy Lynch with the National Shooting Sports Foundation, California Sportsman's Lobby, Outdoor Sportsman's Coalition, Safari Club International, all in support of the bill.
Chairman and members, Sam Paredes representing Gun Owners of California in strong support of this bill. And for staff, Boycine versus United States is a Supreme Court case that is presently being heard right now that where they are saying that a misdemeanor violation cannot be used to abridge somebody's constitutional right. Thank you.
Thank you.
Good morning. Roy Griffith on behalf of the California Rifle and Pistol Association support the bill.
Thank you.
On behalf of San Diego County District Attorney Bonnie Dumanis, we support the bill.
Thank you.
Sean Hoffman with the California District Attorneys Association in support.
Thank you.
Gerald Williamson, private citizen owner of firearms, in support.
Jonathan Feldman, California Police Chiefs Association, in support.
Thank you.
Ken Greenwood, firearms owner, like the previous fellow, full support. It's about time.
Thank you very much. Are there any witnesses in opposition?
Mr. Chairman, members, Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to the Assemblywoman's bill. In November 2014, in our statewide general election, California voters approved Prop 47, which, among other things, reduced classifications of certain nonviolent felonies and wobblers to misdemeanors. The voters made their decision after being fully apprised of the arguments now being raised in support of AB 1869. Specifically, they were told in the official voter information guide published by the California Secretary of State and mailed to every California voter that stealing a handgun valued at less than $950 would no longer be a felony. They were told, and I will reiterate here today, that the proposition would maintain felony penalties for many other gun crimes. Specifically, they were told that in possession of a stolen concealed gun and possession of a firearm by a person convicted of a felony. Likewise, a person could still be convicted of a felony if the person stole a firearm from a home or a commercial establishment or stole a gun from another person by force or fear. If a person injures another person with a firearm, the person can be punished by a multitude of felonies. These penalties were in place before Prop 47 and remain in place today. And despite all of these arguments, voters still overwhelmingly passed Proposition 47. Given the breadth of the existing statutes punishing gun crimes, we do not think that it's necessary to undo the informed choice of California voters on this issue.
Dennis Cuevas Romero with California Attorneys for Criminal Justice. CACJ believes that prosecutors still have many avenues to bring a felony prosecution for those that steal firearms, particularly people that steal concealed stolen firearms is a felony. In addition, under any theft of a firearm from a dwelling, a closed store, locked car, or person is still a crime for a felony conviction under Prop 47. For these reasons, CACJ is still in opposition.
Any other witnesses in opposition?
Lee Prosecutor with the California Public Defenders Association in opposition for the reasons previously stated. Thank you.
Okay, thank you. Are there any questions for members? Okay. Yes.
I'm going to read from the analysis. The drafters of Proposition 47 stated they did not intend to reduce the penalty for the theft of a firearm. The rebuttal to the argument against Prop 47 contained in the ballot argument stated, Proposition 47 maintains penalties for gun crimes. Under Prop 47, possessing a stolen concealed gun remains a felony. Additional felony penalties to prevent felons and gang members from obtaining guns also apply. The problem is that legally, although the ballot argument by itself means that this is what they intended, that doesn't mean they didn't inadvertently do something else. So I supported this bill last year. It was held in appropriations, perhaps to see what happens as the court looked at this. As the courts have been looking at this, there's clearly ambiguity, and so I think it behooves us to go ahead with this bill. Thank you.
Thank you. Are there any other questions from members? And I'm going to go ahead and recommend an aye vote. And the key for me is you're allowing the voters to make a correction. If they felt that is what they intended, then they will vote accordingly. And that is probably the beauty of this bill. You're really just going back and asking the voters what their true intentions were. And so with that, I'm requesting an aye vote from the committee. But I need a motion first. It's been moved. Okay.
The motion is due pass to the Elections and Redistricting Committee. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, aye. Lackey? Lopez? Lowe? Quirk?
Aye.
Quirk, aye. Santiago? Santiago, aye.
That measure passes. Thank you. And now, Mr. Gibson, 1673, item number 3. Oh. Come on. I know. I called Mr. Gibson first, so let Mr. Gibson come up. Yeah. You're next. This will be.
Thank you very much, Mr. Chairman and members. I'd like to start off by thanking the committee chair and the committee for working with us on this bill. We presented this bill at the committee last hearing, and we have taken draft clarifying language to make and strengthen this bill and make it better. We have already taken the amendments on this bill today, which makes it clear that the objective we're trying to regulate must be a receiver blank casing or machine body that is clearly identifiable as a component of the functioning of a weapon. I respectfully ask for your aye vote.
Yes, Mr. Santiago. Is there a second?
Second.
You have been moved and seconded. You have witnesses. Don't talk past the yes. Witnesses in support.
Go ahead.
Ari Freilich on behalf of the Law Center to Prevent Gun Violence.
Amanda Wilcox on behalf of the California chapters of the Brady Campaign to Prevent Gun Violence. I won't repeat my statement from 2 weeks ago, but this is a very alarming development in California, the problem of assembled receivers from weapons that are unknown. We want a background check and record for every gun that is possessed or sold, and this will help achieve that.
Thank you. Are there any other witnesses in support?
Matty Hyatt from the California Civil Liberties Advocacy. We are in strong support. AR-15s have been used in all of the most high-profile shootings over the past few years, and our research revealed that these receivers can be bought in kits online by anyone, including felons. There's no background check at all, and you can get all the information online to put them together. All you need is a drill press, some hex wrenches, some drill bits, a router, masking tape, and a jig that is available from 80%.com.
Thank you.
That they make for this. So we are in strong support.
Thank you. Are there any other witnesses in support? Any witnesses in opposition? There they go. 2 witnesses, 2 minutes. Okay. So we have 2 witnesses, 2 minutes. So, and we've heard this before.
Mr. Chairman, members of the committee, Ed Worley with the National Rifle Association. I, too, share your frustration in this endless quest to try to fix this bill, because the bill still doesn't work, and let me tell you why. The bill says if it's a casting or some other object that could theoretically be made into a firearm, that you're going to categorize it as a firearm. Well, here's your problem. Once you categorize that object, whatever we're talking about here today, in order for it to be a firearm, anybody who manufactures that object, whatever it is, has to affix a make, model, and serial number onto that object in order for it to be lawfully possessed. The challenge is now you've said this object, whatever it is, that nobody can figure out, has to be drossed. Well, in order for that object, whatever it is, to be drossed, it has to have a make, model, and serial number. Well, there's no specifications in this bill specifying how you put the make, model, and serial number on the object, where you do it, how you do it, where it's going to be. The very fact that if you put whatever you put on it, you could have duplicative serial numbers. The challenge then becomes is that what happens to the people who have these objects that are sometimes used as different things, they're used as paperweights and everything else. Now that you've categorized that object, whatever it is, as a firearm, those persons in possession of those objects are now criminals because that object no longer doesn't have a serial number on it, which is required by state law for it to be a firearm. The other challenge you have is there are many objects out there that are simunition firearms that are not, that if you looked at them, you would think they're a firearm. They're made to fire blanks. Well, under this provision of the statute you're looking at now, the way somebody's tried to define this, is that those very objects and those very devices that are intended to be training devices that don't fire live ammunition but could be converted by somebody with illegal means could be considered a firearm. So now you're going to make all those simunition training devices, and including probably movie props, firearms. That's why we oppose the bill. Thank you.
Thank you.
Craig DeLuz with the Firearms Policy Coalition. Once again, I also want to first, I want to thank the committee for putting in the due diligence on this, and I want to thank the staff for their efforts to do the impossible, and unfortunately, the impossible still has not been done. This bill, the language is almost actually worse. When you talk about clearly identifiable as a component for a functional weapon, well, a trigger group, a stock, a muzzle are all components. Additionally, when we talk about clearly identifiable, what I shared with the committee was 2 receivers. One is a receiver for an AR-15. The other is a receiver for an airsoft rifle. Most people, and I'm sure if you look at them, cannot tell a significant difference between the two. So if someone has that airsoft receiver, they could in fact be arrested because it's quote unquote clearly identifiable. For the last month, I've been coming in and out of the building, and I've been carrying with me an AK-47 unfinished receiver. Now, if your trained staff who are out there can't identify it, then it's not clearly identifiable. The point that I'm making here is that this is a clearly subjective definition, and when we start talking about attaching criminal liability to it, we should not be utilizing subjective definitions. It is for this and many other reasons that we encourage your no vote.
Thank you. Are there any other witnesses in opposition?
Chairman, Kathy Lynch, representing the National Shooting Sports Foundation. We, too, think that these amendments make the bill worse. We had offered to the committee and the author's office a federal definition, which apparently was rejected. So you're creating actually two different standards as well. So we oppose the bill.
Thank you. Yes, sir.
Chairman and members, Sam Paredes, Gun Owners California. For all the reasons stated by my colleagues, we are in strong opposition to this bill.
Thank you, sir.
My name is Gerald Williamson. I own an AR-15 made from one of these 80% lower receivers. I don't feel this bill would make us any more safe. It doesn't prevent the tragedy in San Bernardino. It burdens small business and creates extra expense for businesses that are engaging in commerce this way. It offends the Fourth Amendment because it constitutes an unreasonable search without a warrant or probable cause of me. And it also adds an additional burden onto the Second Amendment right to keep and bear arms for individual citizens. So I oppose the bill.
Thank you.
Roy Griffith on behalf of California Rifle and Pistol Association, oppose.
Thank you.
Ken Greenwood, firearms trainer, firearms owner. I am clearly identifiably in opposition to this bill.
Thank you. Does anyone have any questions, particularly to the amendment? Go ahead.
So the chair and I asked last week that you take a look at the definition. I think there were justifiable questions last week. I don't think there are justifiable questions this week. Let me just read the definition. Firearm includes the frame or receiver of the weapon or a frame or receiver blank, casting, or machinable body that is designed and clearly identifiable as a component of a functional weapon from which is expelled through a barrel a projectile by the force of an explosion or other form of combustion. I think that's pretty explicit and pretty undeniable. Further, movie props, one of the questions that was raised, are already exempted. Certainly someone who has something like this, if they have a reason to have it around, can put a serial number on it. And again, once you say clearly identifiable and define essentially what a firearm is, I don't see any concerns with this definition at all.
Are there any other questions? Okay. With that, the chair want to thank Mr. Gibson and the former chair. Want to thank you for your efforts and work on this. It's what you came up with is I think is excellent. It gets us to where we need to be, and your staff and the committee staff have done an excellent job at carving out what we need to say in this. And so I'm almost enthusiastically recommending an aye vote on this.
Thank you very much, Mr. Chairman.
Is there a motion? Who's going to second? Let's by Santiago.
The motion is due pass as amended to appropriations. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, no. Lackey. No. Lopez. Low. Low, aye. Quirk.
Aye.
Quirk, aye. Santiago. Santiago, aye.
Measure passes, Mr. Gibson.
Thank you very much.
And Mr. Chavez, 1802, item number 16. Thank you for your patience, Mr. Chavez.
Thank you for allowing me to address your committee on this simple administrative bill. AB 1802 is actually a continuation of prior legislative action, AB 1317 and AB 702, which deals with the California Victim Compensation and Government Claims Board. In fact, what I'm proposing is actually was recommended by the Legislative Analysis Officer to improving the state programs for crime victims. What this bill does is it moves the board from 3 members to 5, and the additional members would be 1 member would serve as an expert in victims' rights and advocacy. The second member would serve as a physician, psychiatrist, psychologist with expertise in treating or providing services to crime victims. The California Civil Liberties Advocacy has asked me to work with them on the definition of the term expert, and we're willing to do that. As I stated earlier, this bill is about making the process more fair and allow victims to have their voices heard. I ask for your aye vote.
Yes, Mr. Santiago.
Mr. Chair, I'd like to move the bill.
Second.
Thank you. Do you have any witnesses?
I think we're pretty good right now.
Okay. Are there any other witnesses in support? Any? Someone getting up? No. Any witnesses in objection? Okay.
Yeah, California Civil Liberties Advocacy, as he mentioned, in opposition, unless amended, we have agreed to work with them. I just wanted to say our president has worked extensively as a volunteer in victims' rights advocacy. We do support the bill. We just have the concerns about these AstroTurf organizations possibly colluding with the state government.
Turf. Are there any questions from committee members other than what AstroTurf committees?
I had to figure that one out myself. I think it's just a term.
The chairman is recommending an aye vote. Madam Secretary?
The motion is due pass to appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, aye. Lackey? Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago? Santiago, aye.
Measure passes. Congratulations.
Thank you very much, sir.
And Mr. Quirk, 1820, item number 17.
First, I'd like to commend the chair for getting through 30 bills in 2 hours. Excellent. So, good morning, Chair and members. Unmanned aircrafts, also known as drones, can serve many societal benefits, including assessing hostage situations, addressing bomb threats, and detecting forest fires. Despite the possible benefits, without clearly established policies surrounding their operation, the potential for misuse exists. California has no law or regulation governing the use of drones. AB 1820 would regulate the use of unmanned aircraft by law enforcement by doing the following: requiring the development of policies that cover a number of issues, including the following: the individuals who may access the unmanned aircraft system and training requirements, safeguards to protect against unauthorized use or access, mechanics to ensure the policies are mechanisms to ensure the policies are followed, how to operate in a way that minimizes the inadvertent collection of images, footage, and data. It requires law enforcement agencies to post the policies on their website and to present them at a meeting of the governing body to allow for public input. With limited exceptions, data captured by unmanned aircraft systems must be destroyed within a year. Additionally, the bill prohibits the use of a drone over private property unless access to the property is granted or pending an exigent circumstance, a warrant is required. AB 1820 seeks to establish a first-of-its-kind set of regulations on the use of drones by law enforcement.
Thank you. Mr. Santiago?
Mr. Chair, I'd like to move the bill, please.
There's a second. And any witnesses in support?
Yeah, Matty Hyatt from California Civil Liberties Advocacy. We agree with the author. There currently is no law in the books to regulate government use of drones. And we strongly support the warrant based on a probable cause language in this bill. So, yeah, CCLA, strong support.
Thank you. Okay. Any witnesses in opposition? I wasn't sure, Corey, if you were for or against.
That's why I gave you the pause. Good morning, Mr. Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association, unfortunately in opposition to AB 1820. First, let me say we're happy to continue discussions with the author as we go, as we did last year with AB 56 and prior bills attempting to regulate unmanned aerial vehicles. But I would first say that the sheriffs have a general concern about the regulation of UAVs by law enforcement generally. We've seen bills pass the legislature, get vetoed, that try to regulate drones, not necessarily by the use of law enforcement, but in other situations. Those haven't been successful. That's not this committee's fault. But just noting it, just the sort of the context of how the state regulates UAVs. Specifically, we're opposing language in the bill that prohibits the use of a UAV in a jurisdiction outside of the home jurisdiction of the UAV. It would prohibit the use of a UAV to cross jurisdictions in a search and rescue operation, for example. It's also unclear how you keep the drone strictly within the lines of a jurisdiction and how you say, okay, if you're taking a picture, how do you stop and ensure that if you were at the county line, for example, how do you avoid getting in to Orange County from Los Angeles County or San Bernardino or Riverside or whatever the case may be? So that's issue number one. The other issue is that we're opposed to the language that requires the law enforcement policy governing the use of the UAV to be put before the City Council or the Board of Supervisors. And we think public input is often sought and appreciated. We respectfully disagree with the notion that the legislature should tell local law enforcement and local governments how they enact their policies. So, again, happy to continue working, but at this time we're opposed to the bill.
Thank you. Yes, sir.
Mr. Chair and members, Kevin Baker for the American Civil Liberties Union of California, also regrettably in opposition. It is sometimes said that a bill that can join in opposition, law enforcement and the ACLU might be a good bill. Unfortunately, I'm afraid this might not be one of those situations. We do applaud the author for his work in this area. We think that this is an area, the subject of drones is an area where legislative guidance is useful and appropriate. We just think that the bill should be more meaningful in the sense that it now suggests that a warrant is not required in situations where, for example, you'd be followed in a public place. This is the kind of circumstance, for instance, where a GPS is attached, we think is very similar where a warrant is required, and therefore we think that the bill doesn't go as far as it should in terms of making clear that a warrant is required in appropriate circumstances. We also think that the bill should have appropriate penalties. As our friends in law enforcement, I think, would acknowledge, there should be consequences, penalties, some kind of a mechanism to enforce an obligation if there's been a violation. The bill lacks that now, and we think that that's a serious omission, so we remain in opposition. Thank you.
Okay, thank you. Are there any others in opposition?
Chair and members, Jonathan Feldman with the California Police Chiefs Association. We don't have an official position on the bill as of right now, but we do share many of the concerns that were raised by the State Sheriff's Association, specifically surrounding our ability to partner with the sheriffs in the use of these drones. Right now, a lot of our police departments don't possess them themselves and rely on partnerships with the county sheriffs to use these drones for safety purposes in our jurisdiction. We do appreciate the open dialogue that we've had with the author's office and hope we can continue to work on those concerns moving forward. Thanks.
You're welcome. Anyone else in opposition? Okay, are there any questions from committee members? Yes, Ms. Melendez.
Thank you, Mr. Chairman. I just have one question. Mr. Quirk, would you address the concerns that have been expressed about county line issues, whether
Sure.
one can use it or not? Thank you.
Yes. First of all, with respect to search and rescue, that's an exigent circumstance. There would be no problem there. If we need any kind of a clarification in the bill, I'm certainly willing to look at that. Secondly, with regard to, say, a sheriff providing use in various cities, not just the unincorporated areas where they clearly have jurisdiction, as long as there's a proper procedure for doing that, again, public disclosure, and that this is going to happen, we can certainly take a look at language which would allow for a city or another county that wishes to have use of the drone. I'm sure we can come up with language which will allow that. As long as the other county or city is interested in doing it, we'll figure out a way to put that in. Let's see. Then there was a question about penalties. First of all, I think we can depend upon law enforcement to obey the law. If they do not, for some reason, you can certainly bring an action in court. We haven't allowed for a private right of action because that raises all sorts of additional issues, but we are allowing that the way any, we have all sorts of things for which there is not a private right of action, but it's clearly the law. Those things are enforced, and we would expect that to be done here. As far as incidental pictures from one jurisdiction of another, again, I'm sure we can work that out. The main thing that I would insist upon is public input. We're not insisting that there be a vote. We took that out. We had that in last year's bill. We're not having it in this one. But I really think public input is absolutely required.
Thank you, Mr. Quirk. I'm supportive of the bill today and certainly supportive of the efforts. I too have some concerns, some of them expressed by Mr. Salzillo this morning. So I'm hoping that as this moves through the committee process, you might be able to make some changes that would satisfy everyone so that it doesn't get vetoed again by the governor like he did for a former colleague's bill, which was quite similar to yours. I don't.
Well, actually, this one is quite a bit milder. And I would say that I can answer most of the objections, but probably not all of them. But I will do my best to get enough of them addressed so you feel happy with it.
Wonderful. Thank you.
Are there any other questions from committee members? I'm going to go ahead and recommend that we do an aye vote. I will ask the opponents to work with Mr. Quirk. As anyone on this committee will tell you, Mr. Quirk was an excellent chair. What made him an excellent chair is he would try to work through solutions. And I think working with him on this, you will find the same kind of thoughtfulness, and he'll work through most of the problems, and hopefully he'll satisfy everyone here on this committee so that we can get something that hopefully the governor will sign at the end of the day, which is ultimately where we're trying to get to. Okay? Madam Secretary?
The motion is due pass to the Privacy Committee. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey. Lackey, aye. Lopez. Lopez, aye. Lowe. Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago. Santiago, aye.
That measure passes. Thank you, Mr. Quirk. Now we'll do add-ons. Add-ons and changes.
Hold on.
She's
Item number 3, AB 1673, Lopez. Lopez, aye. Item number 5, AB 1695, Lowe. Lowe, aye.
There's a lot. There's a lot. We're at 10, 11.
Item number 14, AB 1771, Lowe. Lowe, aye. Item number 16, AB 1802, Lopez. Lopez, aye. Item number 18, AB 1821, Lowe. Lowe, aye. Item number 21, AB 1854, Bloom. Santiago. Santiago, aye. Item 22, AB 169, Melendez. Lackey. Lackey, aye. Lopez. Lopez, aye. Lowe. Lowe, aye.
All items have been dispensed with. All items have been dispensed with. This committee stands adjourned.